Hello. Today we are going to discuss a very important and interesting judgment of CPC passed by the Supreme Court in the year 2025, that is very recently. This judgment revolves around plaintiff and defendant. The plaintiff and defendant allegedly entered into an agreement to sell for the purchase of some property in the year 1991. In the year 1993, the plaintiff instituted a suit for specific performance against the defendant. However, in the year 1998, in the said suit, the plaint got rejected because the plaintiff failed to file the appropriate court fees in the case. Now, in the year 2007, the plaintiff, again on the strength of the same agreement to sell, filed another suit for specific performance against the defendant. To this, the defendant vehemently opposed, alleging that the suit is hopelessly barred by law of limitation, as the first suit was rejected in the year 1998, and even if the plaintiff could have filed another suit, it would have been near that time, that is within 3 years, as provided under Article 54 of the Limitation Act. Another point which the defendant raised was with regard to that the second suit is also barred by the principle of res judicata. However, the plaintiff took objection to this, and plaintiff based his case on a letter, alleged letter, which he claims to have been issued by the defendant in the same year of agreement to sell, that is 1991, wherein the defendant has said that since there are multiple litigations pending between these parties, that the plaintiff can institute a suit anytime once these litigations are decided. So, when the matter came up before the subordinate court as well as the High Court, they said no, there is nothing like principle of res judicata applies because the suit was not decided on merits, and moreover Order 7 Rule 13 allows the plaintiff to file a fresh suit on the same cause of action if the plaintiff is rejected. However, with regard to the suit being barred by the law of limitation, both the subordinate court and the High Court held that since it is a mixed question of law and fact, and as such it can't be decided over an application under Order 7 Rule 11D of CPC. Finally, the matter came up for consideration before the Supreme Court. Now, Supreme Court considered all these objections and points, contentions of the plaintiff as well as the defendant, and it held. Supreme Court का ये कहना था कि इसमें कोई दोहराई नहीं है that specific performance of contract में Article 54 के तहत the suit should be instituted within 3 years of limitation, which in the present case not a question or not a contention of any of the parties. The suit was instituted in the year 1993 and there was no objection as to its maintainability, and there is no doubt about it. However, in the first suit, the plaint got rejected in the year 1998. Now, the Supreme Court very interestingly relied on a fact. It said that see, once the plaint gets rejected, the plaintiff gets a right to file a suit again on the same cause of action under Order 7 Rule 13. Now, as per Supreme Court, it is different from what generally we think. मैं समझाता हूँ. जैसे लेट्स से मैं एक एग्जांपल दे रहा हूँ. 1991 में कॉज ऑफ एक्शन अरोज हुआ टू फाइल अ सूट फॉर स्पेसिफिक परफॉर्मेंस, बट उन्होंने सूट इंस्टीट्यूट कब किया? 93 में, 2 years आफ्टर इट. व्हाट इज द टोटल पीरियड ऑफ लिमिटेशन इन सूट फॉर स्पेसिफिक परफॉर्मेंस? इट इज 3 years. नाउ व्हेन वी नॉर्मली सी, वी आइडियली वुड सी सर 98 में प्लेंट रिजेक्ट हुई, सो इट शुड हैव बीन इंस्टीट्यूटेड विद इन नेक्स्ट 1 year, दैट इज बाय 1999, क्योंकि 2 साल तो ऑलरेडी हो चुके हैं. टू दिस द सुप्रीम कोर्ट हेल्ड दैट नो, वंस द प्लेंट गेट रिजेक्टेड, now it will be governed by Article 113 of the Limitation Act, which is a residuary provision, which says that the suit should be instituted within 3 years from the cause of action. Now, in this case, the court also said that section 9 of Limitation Act, which says that time once begin to run will not stop, also do not apply. Supreme Court discussed about that there is a difference between intervention and suspension. Now, why? Supreme Court said that once the suit is instituted in the year 1993, then section 9 operation goes out of question, because it applies that it comes only till institution of the suit. Time has begun to run, it's this. It is not a disability. Number 2, it said that since now it has been rejected, and as per Order 7 Rule 13, the plaintiff got a new right. This is a new thing, so it should be governed by Article 113 of the Limitation Act. See, I am trying to make things very easy for you so that आप ये बात समझ पाएं. तो as per Supreme Court, this case could have been filed till 2001, that is 3 years fresh limitation as per Article 113, not 54, should have been filed. However, with regard to the contention of the plaintiff that the defendant in the same year has given him a letter which said that the plaintiff can file the suit anytime once the litigation between the two is settled. With respect to that, the court said if we go or we admit what the plaintiff says, then the letter was issued to the plaintiff in the year 1991, but he instituted the suit in 1993, right? And 1998 के बाद अब 2007 में जब डाला, भैया वो लेटर उनके पास पिछले सूट के टाइम भी था 93 में, उन्होंने उस सूट में उसको कहीं प्लीड नहीं किया जब उन्होंने प्लेंट फाइल करी, अब वो उस लेटर को लेकर आए हैं, और मोर ओवर जब आपने पहला सूट डाला तो उससे पहले का वो लेटर है, तो कोर्ट ने कहा कि ये लेटर जो है ये मानने वाली बात नहीं है. इसीलिए अब जहां तक बात थी, कोर्ट ने कहा कि देखो रिजेक्शन ऑफ प्लेंट का फंडामेंटल क्या है, ओनली द प्लेंट हैज टू बी रेड एज अ होल. और वो सारी प्लेंट को इस केस में पढ़ने के बाद एक बात जो कोर्ट ने कही कि ये बात बिल्कुल ठीक है, जनरली द क्वेश्चन ऑफ लिमिटेशन इज अ मिक्स्ड क्वेश्चन ऑफ लॉ एंड फैक्ट एंड शुड बी डिसाइडेड ओनली आफ्टर टेकिंग एविडेंस, right, after being framed as a issue, not under 7 Rule 11. However, where the facts are itself clear from the plaint, in the case like the one in hand, the court held that yes, the plaint can be rejected on the ground of limitation as well. And in this case, as per the Supreme Court, the plaintiff should have filed the suit, second suit, maximum by the year 2001, that is 3 years from 1998 as per Article 113, which he has not done, and as such now the plaint in the second suit stands rejected. So आपको समझ आया, ये बड़ा इंपॉर्टेंट प्रिंसिपल है लिमिटेशन एक्ट और सीपीसी का, क्योंकि जनरली स्टूडेंट्स या लॉयर्स हमेशा ये सोचते हैं कि सर स्पेसिफिक परफॉर्मेंस वाली बात ही यहां से चलेगी. अब इससे आप कितना सहमत हैं, कहाँ तक सहमत हैं, वो देखने की बात है. हाँ, कई बार स्टूडेंट्स के मन में आता है कि सर इसमें सेक्शन 14 भी तो आ जाएगा. सेक्शन 14 जो है वो अप्लाई करता है व्हेन अ पर्सन इज बोना फाइड इन गुड फेथ लिटिगेटिंग इन अ कोर्ट एंड द सूट इज नॉट मेंटेनेबल ऑन द ग्राउंड ऑफ some matter of jurisdiction or a cause of like nature. So this does not fall into it, right? So this is a very important judgment, and I think that it will go a long way, and it would be asked in various competitive examinations as well. So I hope you got it. Thank you.